My name's Andrew Stevenson, and I am a solicitor advocate, and I'm also the Secretary of the Scottish Law Agents Society. And I'm going to be speaking to you about risk management in the context of conducting proofs. I'm doing that for two reasons. Firstly, because it's a requirement now imposed by the Law Society that we have to have an hour's CPD in the year on risk management. But also, I think the other reason is that I think it's really handy just to know something about managing the risk involved in conducting a proof, because it will make your job a lot easier and enjoyable in conducting a proof if you're aware of the risks and you're able to manage them and minimise them. So I'm hoping that this talk will be useful to you. I've been conducting proofs now for 30 years. I first conducted a proof in 1992, a divorce proof in front of Sheriff Jardine in Glasgow, which was successful. I last conducted a proof in Dumbarton about 6 weeks ago, and that wasn't successful. So some you win, some you lose, I would say. On the whole, I'd say I've probably not won as many proofs as I've lost. I've probably won about 40%. So I'm not one of these lawyers that comes along and tells you that he's a wonderful pleader and speaker who wins all his cases, because I certainly haven't won all my cases. But what I have done over the last 3 decades is I've built up a fairly good sense of what can go wrong and how you are able, insofar as you can, to avoid mistakes and avoid, or at least minimise some of the risks that are involved. And I'm going to be talking to you about that this evening. It is this evening when I'm speaking to you. I don't know what time of the day it is when you're watching this, obviously. What I've learned throughout my career as a sheriff court practitioner, and also as a court of session practitioner, is that the most important factor that you have to consider is protecting your own back. It's probably the same in all areas of legal activity and enterprise, but it's certainly the case in relation to litigation, that you have got to make sure that you are protected against the various risks of complaint that can be made against you by various parties. And generally speaking, if you set out to protect your own position, you are also protecting the client as well. Usually that is, I mean, not always, and I'll come on to some of the exceptions to that. But what I've found in my career is that turning up on the day in court and just proceeding with the proof is actually the easy bit. The difficult bit and the tedious bit quite often is the preparation. But it's also the most important part, because that in itself will hopefully protect you against some of the risks involved when you're going ahead with the proof. So the way I tend to approach these things is, I think to myself, and it's the same with all areas of law, whether it's executories, whether it's conveyancing or anything else, think about who is likely to complain about you and what are they likely to complain about. So that's being blunt about it. Who's going to complain and why are they going to complain? And the best approach in my view is to ask yourself, in what capacity are you acting in the litigation? Now, you'll be acting in a number of capacities, and each one of those gives rise to various duties, responsibilities and risks. The first one I'd like you to consider is the capacity whereby you are acting as a direct agent for a principal. And that is one where you are in a fiduciary position, you're in a position of trust, and you are required to put your client's interests first. You have to protect your principal. You're the agent, and you have to put the principal's interests first. That's the first capacity. Secondly, you may be conducting a proof on behalf of another firm or another solicitor. And it's a situation I've found myself in many times over the years. Probably more than a third of the proofs that I've undertaken have been on behalf of other agents. And in that situation, you have a duty obviously towards the client, their client. You also have a duty towards them. So you have a duty towards the principal agent. You also have a duty to the individual or the company or whoever it happens to be that's party to the litigation in which you're involved, and you have to look out for them. You have to put their interests pretty near the top as well. But there can be conflicts between the principal agent and their client, and I'll come on to that later on. So the third capacity in which you're acting is as an officer of the court. All solicitors are officers of the court. Party litigants are not officers of the court, which can be a little unfair sometimes in certain circumstances. For example, in terms of your duty to disclose authorities that are unfavourable to your own case. You have an obligation as an officer of the court to do that. In my opinion, you can't let the court be misled on the law. So if you're aware of a reported case which is not favourable to your client's position, you should nevertheless have an obligation to disclose it. Party litigants don't have that duty because they're not officers of the court. Anyway, so that's one important factor where you're an officer of the court. The other one is, of course, you're not allowed to allow the court to be misled. Knowingly, you're not allowed to let the court be misled. Fourthly, you may well be an employee, or you may be self-employed, but nevertheless, whichever you are, you have a duty to look out for how the litigation is being funded, because you need to make sure that you're going to get paid for this. There's absolutely no point in going into court to run a proof if you're not going to be paid for the risk and the responsibility of doing that. If you're an employee, you don't want to get into trouble with your boss for having racked up outlays for court fees, witness expenses, shorthand writers' fees. You don't want to rack up all those costs and then find out you don't have enough funds in hand to cover them and you're struggling to get the money out of the client. If you're trying to run your own business, or you're a partner, you're a sole practitioner, you have to make sure that you get paid for what you're doing. So one of the things that you need to do there is make sure you've got funds up front, and it can be very easy to overlook that. The fact of the matter is that running a proof is a very expensive business, and many clients are very reluctant to give you money up front. They may be happier once the case is over and they've won. They may not be quite so happy if their case is over and they've lost. But in my opinion, in my view, you have to get proper funding up front as you go along. It takes away another risk that you don't really want to have to face, namely, how am I going to get paid? If you've got the money up front, then you will get paid. You just take it out of the funds that you're holding. Another capacity is you may be acting for someone who is in receipt of legal aid, an assisted person, as they're called, and that carries certain risks as well, but not least the fact that you can't get money up front for various costs, and you have to try and get sanction for example, employing an expert witness, and if you do get the sanction, you just hope that you won't have any problems later on getting reimbursement of these outlays. So that's legal aid board funding. You may also find that you have insurance company funding. Now, I haven't done many proofs that have been funded by insurers. I've done a few, but not that many. But in my experience, the insurers were quite demanding in terms of being kept advised of, quite rightly in one sense, being kept advised as to how matters were progressing, whether the case still had merit, whether there had been any material change in circumstances, whether there was any possibility of settlement, and so on. So you have to make sure that you're reporting properly to your insurance company, and that's another risk that you're running, that they'll not be happy with the way you've conducted the litigation. But as long as you keep them posted, you should be alright. The last capacity that I always mention in these talks is that you are the colleague of the solicitor acting on behalf of your client's opponent, and that's worth bearing in mind. You do have a duty to your fellow solicitors to act responsibly, to communicate properly, not to do anything that could be regarded as unethical or disrespectful of your fellow professionals, because although your client and the client's opponent may be at loggerheads, that doesn't mean that the lawyers should be at loggerheads. I've tried throughout my time to avoid falling out with colleagues. Sometimes you have to, depends who you're dealing with, but it's not worth doing that. It's not worth falling out with anyone in this job unless you find yourself unavoidably having to do that. So let me turn, if I may, back to the first of these capacities I mentioned, which is the one where you are directly acting on behalf of a client. Now, it's well known that clients are generally unhappy about three things. They're unhappy about unfavourable outcomes. In other words, if they lose the case, they're not going to be happy about that. They're going to be unhappy about delay. Now, I don't just mean the delay involved in a court action, because court actions always take longer than people think they'll take. I've never had a client say to me that didn't take as long as I thought it would take. They've never said that. In the same way, I've never heard a client saying that didn't cost as much as I thought it would cost. It always costs more, it always takes longer than they think it will take or cost. And that's the third matter about which they could be unhappy, the cost. Because cost and delay can quite often be linked. But these are the three things that clients will complain about. And what I've done in these talks in the past is I've mentioned a few quotes from various eminent individuals. The one that you'll see quoted in MacPhail is the one from Jeremy Bentham, the famous English philosopher, who says that vexation, delay and expense are the burdens inseparably attendant on judicial procedure. And he was saying that 200 years ago. There's also a really good quote from a Roman historian called Ammianus Marcellinus, who was writing in about 400 AD. And he said, and I'm translating this from the Greek, because his original book was written in Greek, not Latin. He said, it's an inborn characteristic of almost all litigants to think it the fault of their advocate if they lose their case. Though this may happen through any of 1,000 accidents, it's always the advocate, never the weakness of their case, or, as often happens, the partiality of the court. Well, I don't want to say anything about that these days, partiality of the court, but certainly in 400 AD that was a complaint being made here. Partiality of the court that is responsible for the result, and their anger is concentrated upon their advocate alone. So he was writing that 1400 years ago. And there's also a quote which is quite a good one it's far more up to date, and it's from a case from 2004, Susan McNeish against the Advocate General, and this was temporary Sheriff J. Gordon Reed QC, as he was then QC, and he said, litigation is a risky business. For one reason or another, it rarely goes according to plan. So, which is true. So it's well known that litigation is risky, and this is why it can be a problem when clients are going to complain about unfavourable outcomes and delay and expense. There's nothing new about any of this. We do, I think, live more in a blame culture, however, and whereas at one time members of the public were more likely to take on the chin any unfavourable result, these days people are more inclined to blame their lawyer. Unfortunately, I've noticed that over the last 30 years. I'm not sure how that's come about. I don't suppose it matters how it's come about. The issue, I suppose, is how do we address it. People nowadays, clients are now treated as consumers. I mean, even the Law Society calls them consumers now. And there's more of I think there's been an erosion of respect for all professions, teachers, doctors, everybody, including lawyers. One of the things that I've recognised, or I've noticed, throughout my career, is that there can be tensions over how you minimise the risks of complaint and how you best promote your client's interests with regard to cost and delay. What I mean by that is there will always be more evidence out there than your client leads, and you have to draw the line somewhere in terms of how much evidence you choose to lead at a proof. I had a proof in 2018 where the client wanted me to call 14 witnesses, including a company director in North America. Absolute overkill. We didn't need 14 witnesses, and we actually ran the proof with 3 witnesses, and none of them were actually out with the West of Scotland. The proof was in Glasgow, and all the witnesses were in the West of Scotland. So the clients will always say, I need to bring so and so from wherever, and you need to be very kind of, cautious, careful about that, because all of these witnesses will cost you money in some way, probably, and time. The other problem, of course, is that there can be a temptation to call witnesses who you maybe don't need. The only complaint I've ever had to the SLCC involved a situation like this. What happened was I had a proof in Paisley Sheriff Court in 2013, and it was a preliminary proof where I called a number of witnesses, and the client lost the case, and he lost the case because the sheriff thought he was a liar. Fairly straightforward point on which to lose a proof that you're lying. However, he didn't think that was right. He didn't think he was a liar. What he thought was what he said he thought was that if another witness had been called, then the whole outcome would have been different, which was utter nonsense. But he pointed to the fact that he'd said to me that he thought this witness might be useful, and I had said to him, well, I don't think that witness will be that useful, and by calling that witness we would have prolonged the proof, because what had happened was we'd got to the point in the day where 4 o'clock, we got to the point in the day where we were having to adjourn, and this witness, who was in Spain, hadn't given evidence, wasn't even in the country, he was still in Spain, and the choice was we either have another day of proof, which wouldn't have been soon, where we brought this guy over and he would have been about 15 minutes in the witness box, or we just called it a day and said, well, that's the evidence finished, and it would have gone to have his andum. So what happened was we had a chat about it, and I said to him, I don't think it's worth bringing this witness all the way from Spain just to say what he has to say, because that evidence has already come out from other witnesses. We don't need to corroborate it. And he took my advice, so we didn't call that witness. But as I say, he then complained about me later on and said if this guy had been there, it would have turned the tide, the whole outcome would have been different. Now, as it turned out, the SLCC threw out the complaint, which was always what I thought would happen. But nevertheless, it's not a pleasant experience being the subject of a complaint like that. The problem, of course, is what do you do? How could that have been avoided there? Well, it could have been avoided if the witness had been called, but he still would have lost the proof. And not only that, the expenses would have been higher for him. But maybe with hindsight, I should have called that guy. I should have brought the guy from Spain. But then he probably would have found something else to complain about. So I don't know. I don't know what the solution is to a situation like that. But it is one where it's a situation where you just have to try and use your judgment, reach a reasonable balance on how much evidence to lead as against the cost and the delay that could be involved in doing that. In a sense, though, you can see that there is a conflict there, because I was giving him advice on the basis of what I thought and believed were his best interests, which were, don't bother bringing unnecessary witnesses, don't call witnesses you don't need, that's just wasting time and money. And essentially that's what I was prioritising. I was prioritising his interests by not calling this witness. But having regard to my own interests, what I should have done was called that witness to protect myself against the risk of this guy complaining. So it's a situation where you can, there's many situations where you can have conflicts of interest, and that was one. A similar one was where I had a proof once in Kilmarnock Sheriff Court involving a breach of missives situation, and I acted on behalf of the seller, and he was the defender. So the pursuer called all the pursuer's witnesses, and I felt that there wasn't enough there for the pursuer's case to have been proved, and I didn't really see that there was any need for the defender, for whom I was acting, to give any evidence. However, he wanted his day in court, he wanted to give evidence. So I had a chat with him about it, and he said, no, I want to have my say. And I said, well, okay, you're in charge, as it were, you're the boss, I'll do what you want. I'm only advising you. You don't have to take my advice, but I do have to follow your instructions. So he gave evidence, and of course, he was cross-examined, and one of the things that came out was extraordinarily damaging to his case. It was all to do with whether or not he had seen that the buyer's daughter was disabled. And this had a massive effect in terms of quantum, because what had happened was the sale had fallen through and the purchasers had to make alternative arrangements for accommodation, and they'd had to make particularly difficult arrangements because of the daughter's disability. Now, that would have been relevant in damages only if the seller, my client, had it within his reasonable contemplation, if you like, whether, in other words, whether it was reasonably foreseeable that one of the consequences of his failing to sell the property was that this additional expense and inconvenience would have been caused by virtue of the fact that one of the family members was disabled. Now, there wasn't, when the pursuer's case finished, there wasn't actually any evidence that my client had seen the fact that this girl was disabled. She was in a wheelchair. But during cross-examination, he conceded that he had seen that she was disabled. So it's a situation where if he'd followed my advice, he wouldn't have given evidence at all, and that evidence about his having seen the girl in the wheelchair wouldn't have come out. Whereas, as it turned out, it did come out, and he lost. He was always going to lose, by the way. The proof was largely in relation to quantum. It wasn't really liability. But it was far worse for him because he chose to give evidence himself. So, as I say, you can give advice, but your client doesn't have to follow your advice. But you do have to follow your client's instructions. Another point I would make about that, about instructions, is instructions can be withdrawn at any time, and a client does not have to give you a reason as to why he or she is sacking you. It may be that they don't like the advice they're getting, it may be that they just don't feel comfortable with you, they feel you're not doing a good job, or they could do better themselves or with someone else. It doesn't matter. The fact is, they can withdraw instructions at any time. And this goes back to my point about making sure that you're properly funded. And don't assume that you'll still be acting for this person at the end of the case, because you may not be. So make sure you get proper funding up front. The other thing, of course, is that one of the few advantages that we still have as solicitors is that we're not compelled to act for anyone. We're not like teachers who can, teachers can't refuse to teach somebody, or doctors can't refuse to treat someone unless they've got a really good reason for it. Whereas we don't really have to act for anybody. We can just say, well, sorry, we don't do that kind of work, or we don't have time, or we just don't have the ability to do it for you, and send them somewhere else. And it's worth mentioning that, and this is for younger viewers, if you feel uncomfortable with a client, if they are pressurizing you, if they are trying to induce you to do something unethical, then don't act for them. Just say, I'm sorry, but I don't think that this relationship of advisor and client is working out. I feel you'd be better represented by somebody else, and don't act. And as long as the client isn't prejudiced, as long as you're not withdrawing from acting the day before a proof, for example, you're fine. I don't think there's anything wrong with that. Then the client can go somewhere else. So don't ever feel that you are required to act for anybody. Turning now to agent for another solicitor. And as I said, I've done, I'd say at least a third of the proofs I've done have been on that basis, and I know a lot about it. I have it in my notes here, by the way, that in 2019 every single proof I conducted was for somebody else. It happens a lot to me. And this can give rise to various conflicts. For example, you get sent into court with a set of pleadings that's not up to much. I mean, that has happened to me a few times. Or what can happen is a principal agent hasn't called an important witness, hasn't lodged an important document. What I would say about that is you can see that there's quite a stark risk of a conflict of interest between your duty to the principal agent and your duty to the principal agent's client. You can see there's a conflict of interest between the client and the principal agent. What I would suggest, what I try and do there, is make sure that as regards the advice to the client, you and the instructing agent are on the same page. The last thing that you want to be doing is saying to the client in court on the day something that's different from the advice they've been given by the principal agent. I mean, that is a recipe for disaster. So ensure that you and the instructing agent are saying the same thing to the client. And this includes managing client expectations. I once conducted a proof, a family proof in front of Sheriff McGowan in Glasgow, and it was a guy who was looking for contact, or it might even have been access. I'm not sure. You'll know that changed in 1995. Custody and access changed to residence and contact. Anyway, whatever the terminology, he was looking to see his 15-year-old son. And the father, he led a chaotic lifestyle. He had a drink problem. The 15-year-old boy didn't want to see him, hadn't seen him for, I can't remember how long it was at least a year. The boy was doing well at school, he was settled, he had no problems whatsoever, and there really wasn't any benefit to the father seeing him. And no one, including the curator ad litem who'd been appointed to the boy, thought that it was a worthwhile exercise for the boy to see him. And everyone recognised that you cannot force a 15-year-old boy to see his father if he doesn't want to see him. I know that there still are parental rights and responsibilities while someone's under 16, but realistically, when somebody's 15, and in fact I think this boy was 15 and 3/4, I mean he was virtually 16, the whole thing was basically a futile exercise on the part of the father. And I had the misfortune, if you like, of having to run this proof for the father, which I did. And I remember I had 3 solicitors on the other side. There was one for the boy, no, there was a curator ad litem, there was one for the mother, and there was one for somebody else. I think it might in fact have been a child welfare reporter. I can't remember, but there was 3 solicitors on the other side. And it was a complete no-hoper. And I knew that. And needless to say, it was not successful from my perspective. However, the good thing about it was that the client had been told by the principal agent, and he'd been told by me, you are not going to win this case. His expectations were managed appropriately, both by me and by the principal agent. So there was no issue about him coming away disappointed, feeling that somebody hadn't done their job properly, that he'd been let down, he hadn't been represented properly. There was none of that, which took the pressure off me, took the pressure off the principal agents as well. And that was a good example of where, as long as everybody's aware of where they stand and what the prospects are, then the risk of complaint is minimised. You might say, well, what was the point of running that proof at all? Well, the whole point about running it was that he wanted to be able to say to the boy later on in life, if he ever saw him, that he tried his best to see him, which I thought was fine. I thought that was a reasonable approach to take. Whether that ever did happen or not, whether the boy and the father ever got together again, I don't know. But nevertheless, that was what happened. So make sure that you're on the same page as your principal agent. Also, excuse me, that can be very important if it comes to an action involving money. You don't want to have a situation where you're telling the guy on the day of the proof that an offer of £10,000 should be accepted when the principal agent's already told him not to take less than 15,000. You can see that the client will be completely baffled in that situation when he's getting conflicting advice, and you'll think somebody doesn't know what they're talking about. So you've got to make sure that, as I say, there's proper communication between yourself and the principal agent so that that kind of issue doesn't arise. Because of course proofs are stressful enough as it is without the client getting conflicting advice about settlement. How about the situation which I've come across where you turn up to conduct a proof and it soon becomes clear that the instructing agent hasn't done something which they should have done, like they haven't lodged a production on time or at all? Well, in my view, generally speaking, you have got a duty to look after your instructing agent's interests by not exposing them needlessly to a risk of complaint or criticism. So that's a duty that I think you have. However, you also have a duty to be straight, candid, honest, and open with their client. You can't sacrifice the client's interests just to protect your principal agent. But there are ways in which you can try and manage the conflict. What I've done in the past is made the best of it by looking at it in the sense that there isn't much of a conflict in this. Say for example it's a late production that's been lodged. You don't really have a conflict there between the client and the principal agent because they both want that production received. Where there's a conflict is if it isn't received, and then there's prejudice. And what can happen there is a proof has to go off, or somebody gets hit, or there's a penalty and expenses, and you then get a situation. Well, who's paying those expenses? I think that in that kind of situation, you just have to make the best of it. Hope that the error or the misunderstanding, whatever it is kind of not of such seriousness that it causes jeopardy, that the sheriff allows something in and the conflict doesn't materialise. If it's more substantial, you maybe have to take a different approach to it. One of the problems that I've encountered is in relation to precognitions, and I've seen some terrible precognitions insofar as the language that's used in them is so unrealistic. There's just no way that those are the words that were used by the witness. It's just people having words put in their mouths by someone precognising them who just wanted a particular line or a particular statement or remark to be there, and I'm not saying they've they've made it up completely, but they've distorted what the witness is saying and is likely to say, and that kind of recognition is more harmful than anything. Errors can come in, omissions can occur, and it just causes problems on the day. There's a good quote by Lord Justice Kerr Thompson in Kerr versus Her Majesty's Advocate from 1958, which is quoted in MacPhail, and he said that precognosers as a rule appear to be gifted with a measure of optimism which no amount of disillusionment can dampen. And I've had situations where I've gone into court with a precognition that looks great, and the witness just has not come up to the standard or the utility, if you like, of the precognition. They've said something else. They haven't said something that's in the precognition, and you then have to try and get yourself out of that mess. I once conducted a proof in Falkirk. It was all to do with a traffic management system, cones and signs and temporary lights and all these other inconveniences that you see on the roads when somebody's doing roadworks. And I was representing the Pursuer Limited Company, and the case on record was simple enough. It was that they'd done the work and they were due to be paid for it. The precognition of the main witness was consistent with the pleadings, and the defence was that a named individual within the Pursuer company had waived a large part of the fee because of variations that had taken place after the contract had been entered into. The Pursuer's case was that this individual was someone who'd left the company, that they didn't know what he'd said to the defender, but even if he had waived part of the fee, he didn't have the authority to do that. And if he had waived the fee or part of the fee, he'd overstepped the mark, he'd exceeded his authority, and it wasn't binding on the pursuer because the individual had no actual authority. But what the record and what the precognition failed to mention was that the individual had actually been the pursuer's contracts manager at the time. And in my view, that omission was extremely unfortunate, because if that guy had been the contracts manager, and the witnesses who were there for the pursuer said he had been, that he was the contracts manager, in my view, there's a high likelihood that the court would have found that he had ostensible authority to waive a large part of the fee. I mean, he was the contracts manager. He wasn't a labourer or an electrician or a tradesman. He was the contracts manager. And if that proof had gone ahead, it would have come out that the guy was the contracts manager, and the pursuer would almost certainly have lost. So there'd been a really bad blunder there by the principal agent. And I think this guy had been described as a member of staff or something neutral that didn't really tell you what his role was. So it gave me a bit of a problem, because what was I to do there? Should I tell the pursuer's director who was there, the witness that was there, that the principal agents had blundered? I didn't want to do that. It's not the kind of situation where you can just muddle through there. You can't just play that by ear. The risks are far too high. I tried to get hold of the principal agent, which is of course what you should try and do, and not have to make the decision on your own as to how to get out of that kind of situation. But I couldn't get hold of the principal agent. As it turned out, the opponent's lawyer made a settlement offer on the day, because it was only part of the fee that had been waived, allegedly. So he made an offer. I took instructions on it. We went to and fro. I was a bit slower than I would have been normally. The upshot was, it took so long, the sheriff took another proof, ours went off, lack of court time, which was the best result we could have achieved on the day, because the thing went off, and I was able thereafter to explain to the principal agents that they were in serious difficulties as regards this managing director. What happened after that, I have no idea, but I didn't get instructed to do any follow-up proof, so I'm assuming it was disposed of. But that was a lucky situation, because it avoided me having to say to the principal agent's client that there'd been this incompetence, which is what it was. And then we didn't have to have a blame game about whose responsibility it was, as between the instructing agent or the client or whoever it happens to have been that made that mistake. Of course, I was partly responsible for that situation as well, because what I should have done was I should have been crystal clear as to who this person was before I went into court. I mean, I went into court being told he was a member of a member of staff or something, but I should have been clearer as to who he was. And if I'd actually made better inquiries and I'd been told he was the contracts manager, I'd have said, wait a minute, he probably did have ostensible authority to say what he's alleged to have said. It highlights though one of the problems that you'll get, and I've had it a few times, where if you're only instructed a few days before or the day before, then you quite often don't have time to digest it and make inquiries and check things. If I'd had more time there, I might have thought, well, who is this guy exactly? And I might have made inquiries, but I didn't. It doesn't help that quite often instructing agents will wait until the last minute before giving you the papers. I used to do an awful lot of road traffic proofs for a firm, and the case is usually settled, and the problem with that from my perspective was the principal agent wouldn't give you the papers too far in advance, because if they gave you them too far in advance, they then have to pay you for having prepared for the proof. But if they waited until a couple of days before, then their hope was that it would have settled by that point, they wouldn't have to instruct you at all. That happened a lot, and getting the paperwork the day before or 2 days before just adds to the stress, and it adds to the situation that I've mentioned there about that case in Falkirk. That partly came about because I didn't get the papers till the last minute. The shortest notice I've ever had for doing a proof is half an hour. I did a road traffic proof in front of Sheriff James Murphy in Glasgow, and I got the papers about half an hour before the proof, and I read them in the taxi going down the road. Luckily, the sheriff knew that, so he was very he actually found it quite amusing, but he was very tolerant of the whole thing, and it worked fine. I actually won the proof. Very straightforward case, but I wouldn't recommend to anyone that they do a proof based on papers provided half an hour before. As regards doing a proof for somebody else, if you can, I would recommend speaking yourself to not necessarily all the witnesses, but the main ones, before the day itself, just to make sure that the precognitions are actually right, and are consistent with the pleadings. And that way, if they're not, then you've got an opportunity to do something about it, which can be amending, can be, well, you obviously wouldn't amend, you'd tell the principal agent, I think you should amend. Or it can be seeking clarification, or different witnesses, or additional witnesses, or whoever. But the more notice you've got the problem, the better, the easier it is to do something about the problem. Yeah, so try and speak to the key witnesses in advance. The other thing that you should always do is, unless the principal agent is going to be at court as well, what I mean by that is they'll be there but in a different courtroom doing something else. I've had that a few times where you're instructed by a firm and they've got solicitors down who are doing trials, but they've got a proof as well, and you do the proof and they do the trials. So if they're around at court, that's good. But otherwise, make sure that you've got a line of communication directly back to them at all times, because if something goes wrong, you can get on the phone to them and say, listen, this is what's happened, what do you want to do about it? It's always better if they take the decision rather than you do. If you get a situation where something's not there, like a piece of evidence, like an invoice or a receipt, delivery note, something like that, you can, if as long as you've got a means of communicating with the principal agent, you can always ask the court for 10 minutes to go and check something, or go and make a phone call. Bear in mind, sheriffs themselves have usually undertaken and conducted proofs themselves, so they know what can go wrong. And in my experience, sheriffs are very understanding about things like this. And if you say to a sheriff, something has come up, my lord, I need to take instructions from principal agents, I've never had a situation where they've said no. They understand that there are logistical issues, that things can go wrong, that you're trying to do your best, and sheriffs, in my experience, are very understanding about these things. So if you do get yourself into a real guddle, just ask for a bit of time, 10 minutes, which is will usually end up being 20 minutes, but ask for 10 minutes and go make a phone call and try and get it sorted out that way. Another thing that can sometimes happen is that if something's not there, like a receipt or an invoice or something of that nature, the client will say to you, oh, I gave that to Mr. So-and-so, who's, Mr. So-and-so being the principal agent. That can be an awkward situation. But as I say, the best thing to do is just deal with the principal agent, explain what the problem is, and see what they want to do about it. And that applies as well with something like if somebody makes a settlement offer, you're always better off running that by the principal agent if you can, rather than taking a decision on the advice to be given to the client, because the principal agent may have different advice to give. You may think that I'm suggesting that you don't use your initiative, and I'm not saying that, because sometimes you do have to do that. You do have to be able to think on your feet. You've got to be pragmatic, and you're the person on the ground having to deal with a proof. It's easy for the principal agent in their office or wherever, somewhere else. You're the one that's there actually having to deal with a real situation, so you do have to use your initiative. But all I'm saying is, if it's something significant, you're safer to involve the principal agent as well at the time, if you can. So these are all the kinds of problems that can arise where you are acting for another solicitor. The one good thing I would say though is that you shouldn't have any problems getting paid, because Section 30 of the Solicitor Scotland Act 1980 states that a solicitor who employs another solicitor to do work, like conducting a proof, is liable for that solicitor's fees and isn't entitled to rely on the principle that an agent for a disclosed principal isn't personally liable for the disclosed principal's debt. In other words, if you do a proof for another solicitor, obviously that other solicitor is acting as an agent for a principal, but you don't have to sue the principal to get paid. You can go after the instructing agent. That's what Section 30 says. So that's one of the advantages of acting for another solicitor. Another one, of course, is that you're not personally liable for the outlays or the witnesses' expenses. It's the instructing agent that has that responsibility. I don't think I've got much more to say about that. I've had a few hospital passes over the years. It's just one of these things. It's one where it depends who your instructing agent is. If they're a regular instructing agent, you've got a good relationship with them. You like to think they won't give you a hospital pass, and it's just a question of trying to build a good line of communication with them. I'm going to move on now to another capacity in which you may be acting. In fact, you will be acting. You're always acting in this capacity. This is one where you're an officer of the court. And as I always say, if a sheriff ever reminds you that you're an officer of the court, that's not a good sign. Don't take that as anything other than a bad sign. The duty that you're always told about that arises from that is you're not allowed to knowingly mislead the court, and you can't do it knowingly, you can't do it recklessly or carelessly. So for example, if you're asked a question by the court and you don't know the answer, do not guess the answer. Just say, I'm sorry my lord, I don't know the answer, or my lady, don't know the answer, and then go and find out the answer, or try to find it out. But you're always an officer of the court, so you always have that responsibility. It can arise or manifest itself if you're in a situation where your client is trying to conceal something. If you're in a divorce action, for example, a client tells you that he has an asset or an income stream he doesn't want his wife to know about, you cannot be a party to allowing the court to be misled about that. You have got a duty to say to the client that you cannot facilitate that concealment, and if the client insists that you do that you do help conceal the fact, then you must, in my opinion, you stop acting. Perfectly good reason for doing it. In fact, I think you're obliged to. In my opinion, you've got a duty there to stop acting, and I don't think anyone could ever criticise you for doing that. There's no harm. There's nothing wrong with unwittingly being a means by which a court is misled. What I mean by that is, your client can tell you something and it may be an absolute pack of lies. You may think it's a pack of lies, but as long as the client adheres to that story, is consistent about it, then you've got a duty to put forward that case, whether you believe it or not. There's nothing wrong with doing that. It's not your job to assess whether somebody's being credible or not. I've had situations where clients have told me things and I've not believed a word of it. But what I try and do there is I'll say to the client, not I don't believe you, but I'll say to the client, I think there's a good chance the sheriff will not believe you. In other words, I'm not disbelieving the client. It's my concern is that the court may not believe that account or that witness or that story. Sometimes you may, or quite often you may suspect you're being told a pack of lies, but very rarely will it ever be proved that they are, or that at least that the witness or the client will admit that they've told a pack of lies. The only time it's ever happened to me, I had a case in front of an employment tribunal, and what happened there was a witness denied that cash had been paid to an employee. This was all about tax evasion, and the witness denied that money had been paid to the employee. And so that was the end of that, and the evidence itself wasn't that important in the scheme of things, in the context of the action. Anyway, that evening this witness phoned me and he admitted that he'd lied in his evidence, and he apologised, and he said he'd been caught out, he hadn't been expecting to get asked about this. And I must admit, I hadn't thought he'd get asked about it either. He didn't think he'd get asked about it. He panicked and he just lied about it. But he felt that evening so bad about it that he had to get it off his chest and phone me up about it. The interesting thing about that was that if he hadn't told me that he'd lied, there was no way that it would have come out any other way. He wouldn't. His dishonesty would not have been exposed. As I say, it wasn't even an important element of the action. He was not a crucial witness, and he just felt bad about the fact he'd lied, and he told me. So what I had to do was I had to tell the tribunal chairman, and I did that the next day. The consequences actually were fairly minor. Clearly the witness wasn't really someone that they could believe about anything, so he was sort of disregarded. But I don't think they reported him for perjury. I don't think there was really any consequence to him. But of course, as an officer of the court, or the tribunal if you like, I was required to draw to the tribunal's attention the fact that there'd been a lie told to them by this witness. If we hadn't been going back the next day for a subsequent day of the tribunal, I would have written to the chairman, but I would definitely have drawn it to their attention, and I did. That's what I did. So you cannot allow the court to be misled by having evidence presented to it that is dishonest, where you know it's dishonest or false. As I say, you don't say to a client, I don't believe you. You say, I don't think the court will believe you. And if you have to explain why that you think that, you'll just say, well, I don't think the court would accept that what you've said is likely to have happened. I was once in court when it wasn't a proof, it was a hearing, and there was a well-known politician who appeared himself, and the case involved a photocopier, and this well-known politician was being sued by the photocopier company because the photocopier had been in his office. He'd been using it, but he hadn't been paying, so they sued him. And what this politician said at the hearing was that the photocopier company had agreed that it would pay for the photocopier to be moved to the politician's new office because he'd fallen out with the guy he was sharing the office with, moved to another office. The photocopier company had agreed that it would pay to have this machine moved. It would write off all the costs that had been incurred, and that he wasn't liable for any of these charges. I mean, to me, that was just an absolute lot of nonsense, complete cock and bull story. And you could say, if I'd been his advisor, I'd have said, well, I'm not disbelieving you, but I don't think the court will believe that because it just doesn't sound likely. That's what I would have done. But he was there on his own, he didn't have a lawyer. Let me deal with this aspect of being an officer of the court. Being an officer of the court does not mean that you have to avoid standing up to a sheriff. I've seen talks and seminars, and I'm sure you have as well, that are called things like How Not to Annoy Your Sheriff. And quite often these talks are given by sheriffs. But I always think to myself, well, there's nothing wrong per se with annoying a sheriff. It depends entirely on the context. It depends why the sheriff's getting annoyed. So if the sheriff's annoyed because you're asking daft questions or you're bullying a witness, that's fair enough. The sheriff should be getting annoyed about that. On the other hand, if you're conducting a proof and you want to call a witness and the sheriff looks as if the sheriff's made up his mind already and he's getting annoyed because you carry on regardless, then I don't think that's a good reason for the sheriff to get annoyed. I mean, there used to be a sheriff in Glasgow who didn't think that corroboration was something that should be bothered about at all. And once he'd heard if he'd made his mind up when he'd heard some of the witnesses, but you wanted to call a witness to corroborate your client's position, he'd get annoyed about that. He'd say, I don't need to hear a corroborating witness. He would say the Civil Evidence Scotland Act 1988 abolished the requirement for corroboration. So why are we hearing this corroborating witness? And of course the 1988 Act did indeed abolish the requirement for corroboration in civil actions. But that's not the same as saying you shouldn't have corroboration if it helps your case. It just says you don't need it. It doesn't say you shouldn't have it. And I'm always a great believer in corroborating a key witness's evidence. And corroboration can be extremely important in some types of action, particularly road traffic cases. If you've ever run a proof where the only witnesses are the two drivers, then if you've got a witness to corroborate your client's account, that will usually result in a favourable outcome for your client. And if you don't have that corroboration, the sheriff would usually say, well, I don't know who's telling the truth here, I can't make a judgment as between these two witnesses. Pursuer has not overcome the burden of proof, therefore I have to assoilate the defender. That's what would usually happen. So corroboration can be critical in some kinds of action. So if you feel that you have to corroborate evidence by bringing a witness, then don't let the annoyance of a sheriff deter you from doing that. And bear in mind, the sheriff may have got his his or her decision wrong, in which case you may have to appeal. And if you've backed down, and not called that corroborating witness, that could be fatal later on. So stand your ground if you think you're doing the right thing. There's an interesting Law Society practice rule B113, which is headed Relations with the Courts. I'm just reading it just now. It says, amongst other things, it says you must maintain due respect and courtesy towards the court while honourably pursuing the interests of your client. And the practice rules which pertain to solicitor advocates covers this as well. And there's a rule, it's C4419, and it says you must be fearless in defending your client's interests, regardless of the consequences to yourself, including, if necessary, incurring the displeasure of the bench. And I think that rule should apply to solicitors generally. I don't think that should just be solicitor advocates. I think that should be all solicitors. That you should be fearless in defending your client's interests, and if necessary, incurring the displeasure of the bench in doing that. So the moral is be fearless, but don't be daft either. If you're annoying the sheriff by being silly, asking stupid questions, or bullying witnesses, that's usually one that gets sheriffs annoyed. Well, don't bully witnesses. So try and be fearless. Fourth capacity, I mentioned being an employee or being self-employed. It's the same principle insofar as you need to make sure that you have got proper funding. I've mentioned this already. It's really important. No fee, no plea is what our criminal colleagues say, but the same idea applies in civil actions. Going into court is expensive, and you don't want it to be expensive personally. Certain things can happen here, and this is, again, it's risk management. You have to make sure that you're not left in the middle of things. What I call piggy in the middle. Don't ever be piggy in the middle between the client and whoever is owed money. So some of the costs, you probably know this, but some of the costs involved in running a proof excuse me, are the personal responsibility of the solicitor. So there's a number that are quite important, and one of them is shorthand writers. Shorthand writers can be extremely expensive. The court can dispense with a shorthand writer if the parties agree. McPhail makes that point. It's also in the ordinary cause rules. You can dispense with a shorthand writer. I wouldn't recommend doing that. Personally, I don't think it's a good idea to dispense with a shorthand writer, because if you want to appeal, there's no record of the evidence, and unless it's an appeal on a very narrow point of law, the fact there's no evidence, there's no record of the evidence, is really making the appeal court's job virtually impossible. So that's one situation. If you do dispense with a shorthand writer, you won't have a shorthand writer's bill to worry about. The other one is where you haven't actually cited any witnesses, and you aren't really going to have much in the way of a shorthand writer's bill. Of course, as a solicitor, you are liable for half the shorthand writer's bill, even if the shorthand writer's been instructed by the other side. So even if you haven't instructed the shorthand writer because you don't feel you need to have a record made of your evidence, that won't stop you being liable for half the bill in the first instance. So you do have to look out for that cost. Shorthand writers' fees, as I say, can be considerable. Bear in mind that courts will not organise a shorthand writer for you. It's the pursuer who has to instruct a shorthand writer, and that applies even if it's a defender who's leading at the proof. It's the pursuer who has to instruct. I once had a proof where I forgot to instruct a shorthand writer, which could have been a disaster because there was counsel for both sides. Counsel who went on, both of them went on to become judges. One of them was Philip Brodie QC. The other one I won't mention, he's still a judge. But that was a proof in Glasgow, and I just forgot to instruct the shorthand writer. As it turned out, it didn't matter because counsel went and had a coffee and discussed it and settled it. So we didn't need a shorthand writer. But if it had gone ahead, or if the court had wanted it to go ahead, if we hadn't been able to settle it, that would have been an absolute fiasco because we wouldn't have had a shorthand writer there, unless I'd been able to get one. So please make sure you don't overlook that. I've also had a situation where I've instructed a shorthand writer where I didn't need to because there was recording equipment in the court, and again that's another problem, an expense that you need to take on the chin if it's your mistake. On that point, be careful when it's summary applications. There's a section in McPhail about this. This is 4th edition McPhail, and it says here, this is chapter, 26106, and makes a point that evidence is recorded in a summary application only when the sheriff so directs, either ex proprio motu or on the motion of a party, or where the recording is required under the enactment which governs the proceedings. So bear in mind the ordinary cause rules don't really apply there, so you have to be clear in summary application procedure, is there to be a shorthand writer or not. So just get a direction from the court when the hearing's fixed. Is there to be a shorthand writer? Because a shorthand writer is somebody that you need to arrange well in advance of the hearing or the proof. So going back to the situation where you do need a shorthand writer, as I say, the fees are payable in the first instance by the parties equally, but the solicitors are personally liable for the fees. So essentially you're giving a personal guarantee that the shorthand writer will get paid. This is another instance. I remember I mentioned earlier about Section 30 of the 1980 Act about agent of a disclosed principal not having liability, but this is another example where an agent does have personal liability. The rules about how much the shorthand writer's fees are, I'm not going to go into this because it's all in the Act or all in the regulations. It's the it's a 2019 Act of Sederant. The rules before that were the Act of Sederant, fees of witnesses and shorthand writers in the Sheriff Court, 1992. The 1992 regulations and the 2019 regulations are virtually the same in terms of how they quantify the outlays. So you'll find in there, an attendance fee, cancellation fee, subsistence allowance, and the one that's a really expensive element, which is the extension of the shorthand notes. Now, extension of the shorthand notes just means getting them typed up, and that's where it gets very expensive. The other outlays are not that bad, but where there's an extension of the shorthand notes, it can cost a lot of money. In my experience, sheriffs are not asking for extension of the shorthand notes nearly as much as they used to. When I started doing proofs 30 years ago, it was almost universal that the shorthand notes got extended. And nowadays, it doesn't happen that often, which is good. Whether the notes are extended or not is a matter entirely for the court. I mean, it seems a bit strange in some ways that the pursuer has to instruct the shorthand writer. The parties are paying for the shorthand writer, but it's the court that orders the extension of the notes, or not, depending on whether they choose to do so. I always get about £1,000 a day from a client up front for a proof to cover the potential cost of extension of the shorthand notes, because that's the kind of money that you're talking about. You really don't want to get hit in that kind of bill personally. To always make sure that you've got funds up front to cover that potential outlay. The other outlay, the other major one, where you're personally liable, is if you cite a witness. COVID had kind of impacted on this, and where there was a suspension for the need for physical attendance of witnesses, you obviously get less of an expense, right? So in other words, witnesses are not having to travel to court, and travel expenses for witnesses could be a major element of a cost of a witness, particularly if you've got someone coming from London, for example, up to Scotland, or coming from overseas, like from Spain. The witness I mentioned before, who I didn't cite. With COVID, if the person's giving the evidence remotely, their costs are much less. Of course, we're now moving back to physical proofs, which is probably a good thing in many respects, but it does mean that the cost of bringing along a witness is substantially more than under COVID. What I would say about that is, what you need to make sure about is that you've got those costs under control, in so much as you can control them. And I've had situations where I've said to somebody that I'm probably going to be instructed to call him as a witness, and then he'll go away and do something like he'll read notes, or he'll dig out documents or something, and sometimes they will expect you to pay for their time in doing all that. And I think what you have to do there is just have to say to them, look, don't incur any costs, because I'm not going to pay you for them. Make it clear that you're not giving them carte blanche to spend time preparing or refreshing their memory by looking at notes or whatever. Just make sure that you keep them advised about this. It's more of a problem with what you would call professional witnesses or skilled witnesses, but it can also happen with ordinary witnesses as well. I'm not saying that there are individuals out there who will try and milk the thing to make as much money out of the situation as they can, but you do have to be just careful about that. Bear in mind that the expenses that you can recover, your client can recover from the opponent in the event of being successful, the expenses are capped for ordinary witnesses at £400 plus VAT. So it's not the same with skilled witnesses, but with ordinary witnesses there is this cap, and you don't want your client to get hit with a bill from a witness which isn't recoverable or isn't largely recoverable from the opponent. So try and communicate effectively with the witness so that they don't go away and incur a lot of expense. It's also a good idea is to make arrangements with them, to have them at the end of a phone line if that's possible. It's a very common thing where you're dealing with professional witnesses. So for example, if you're in Ayr Sheriff Court doing a divorce proof and one of your witnesses is an accountant who's got an office in Glasgow, the last thing you want is for that guy or lady to be hanging around in court for hours waiting to get called. So what you would do is you'd say, stay in your office, get on with work. How long will it take you to get down to Ayr from Glasgow? And they'll probably say 45 minutes. So you say, well, I'll give you an hour's notice and then you can come down when you're needed. And that way they're not hanging around at court, which nobody likes doing. You're saving money and waiting time, and it's likely to make the witness better, more favourable towards you and your client if they're not being messed about as they see it. Another thing, of course, you can do is obtain affidavit evidence. But of course, affidavit evidence is not as good as parole evidence, so you have to make sure that you're aware of the inferiority of affidavit evidence over parole evidence. The reason for that, of course, is you cannot cross-examine an affidavit, so it can't be tested. But depending on what it is, it can be a very good way of saving money, particularly if the witness is far away, doesn't really have very much to say, and it's not really that controversial. Going back to the costs, I've been discussing shorthand writers, witnesses. The other outlay that you may have to bear personally is in relation to sheriff officers. If you have to instruct sheriff officers to cite witnesses, you'll get the bill for that. So again, make sure that you've got funds to cover that one. There are some grey areas where there can be risks. Interpreters is one of them. These are not provided by the court in civil proceedings, although I have actually seen that happen, but they're not provided by the court. I'm not aware of any rule which makes a solicitor personally liable for the costs of an interpreter. But that's not to say that you couldn't be pursued by an interpreter who claims that you're personally liable because you instructed him. Interpreters vary a lot in quality in my experience, by the way. I've seen situations where a witness can be asked something along the lines of, what did you see? And the witness will put the question in Urdu or Punjabi or another language such as that, and the witness will answer in Punjabi or Urdu for maybe 20 seconds or half a minute, and the interpreter will say, nothing, I didn't see anything. And you're thinking, surely it doesn't take that long just to say nothing. And you're sceptical, you're thinking to yourself, I think the witness might have said more than that. But you're dependent on interpreters. So anyway, costs of interpreters, I think it's something, make sure you've got the funds to cover that cost as well. I think experts that aren't cited by you, this is another grey area. If you instruct an expert but you don't cite the expert witness, my view is that you are not personally liable under the rules because you haven't cited the witness. But there could be circumstances where you are liable. There's a case on Scottish Court's website called White Chiropractic Clinic Limited versus Corries Scotland Solicitors, 12th October 2005. This was a debate before Sheriff Scott, who then went on to become the Sheriff Principal in Glasgow, and I appeared in that debate for the defender, and it was a situation where there was a chiropractor instructed by a company. The chiropractor was cited. He didn't suffer any loss of income because he was paid his salary anyway. He didn't sue. The employers sued the solicitors who had cited him, and the issue was whether the solicitors were personally liable to the employers, even though it wasn't the employers who'd been cited. Now my argument was they weren't personally liable, but it was quite a technical point, and I can't remember what the outcome was, but I do remember that there was an appeal marked, and that the case was settled before it got to the Sheriff Principal, because this was before the Sheriff Appeal Court was created. It was a Sheriff Principal appeal, and it was settled. But the point I suppose I'm making is that you don't want to get into that situation if you're a solicitor. You don't want to be sued and find yourself having to argue a point at a debate or before a Sheriff Principal. The other danger these days is that, and I've seen this happen before, experts or third parties who are involved with solicitors and their own money can go to the SLCC, or threaten to go to the SLCC. So there's all these risks you really ought to try and avoid, and the way you do it is you just make sure you're properly funded. The third area that's grey is where you have the Sheriff Clerk looking to you to pay court fees, and these can be quite substantial amounts of money. I looked at this, and a Sheriff Court ordinary cause proceeding to approve a 2-day proof could cost about £800. Pursuer could pay about £800 in fees, just for having a 2-day proof. Is considerably more than that in the Court of Session, but in the ordinary court, even there, it's expensive enough. Now my view is you're not personally liable for these costs, but I've had the Sheriff Clerk phoning me up asking me to pay fees, and again, you don't want to get into these kinds of arguments. And also, if the fees aren't paid, that will cause problems, because then the Sheriff Clerk won't call a case, and the Sheriff will say, what's happening, why haven't they been paid, and it just becomes awkward and very disagreeable. So again, it's another situation that you want to try and avoid. Another capacity that I mentioned earlier in the context of risk management is where you are acting in a situation where your client is being funded by a third party, namely Scottish Legal Aid Board or an insurer. Now, I've already observed that there are risks about being piggy in the middle when it comes to court costs and outlays. It's more of a problem in a situation where your client's an assisted person, because you're not able to get money up front. The only way of protecting yourself here is make sure you have got sanction for everything. Make sure that your case cost ceiling is adequate, because For those of you who don't do legal aid work, where you're given a legal aid certificate these days, there is a case cost ceiling. In other words, the legal aid board will not pay you above the ceiling. So if you raise an action for damages, for example, your ceiling is £5,000. That is a cap on the amount that the board will pay you. And if you end up spending more than that, then you're at risk that they won't pay you for the extra amount above the ceiling. So always keep an eye on that. Make sure that if you need more funding, that you get it, that you apply for an increase in the ceiling. Bear in mind as well that people will not charge you less because your client is legal aid. So experts, some do to be fair, but a lot of experts will not care whether your client's legally aided or privately funding. They'll say, well, I'm £200 an hour, whether your client's legal aided or not. The only good thing about having an assisted person as a client is that when it comes to costs is that some of them will not apply. The court fees don't apply, so you won't have to pay to enrol a motion or fix a proof or take any of these other steps. I have to emphasise, very important, if you are acting for an assisted person, you have got duties under Regulation 24 of the Civil Legal Aid Scotland Regulations 2002, which is headed up duty to report abuse of legal aid. So if you think that an assisted person has, for example, unreasonably required a case to be continued, you have to tell the board. If, for example, you don't think the client is behaving responsibly in terms of declining to accept a settlement offer, or they just want their day in court, you've got a duty to tell the board, and that duty overrides client confidentiality, which is definitely worth bearing in mind. The rationale, of course, is that private clients are entitled, if they so wish, to waste their own money, but legally aided persons are not entitled to waste public money. In other words, the legal aid board's money in pursuing litigation unreasonably. The last capacity that I mentioned was where you're the colleague of the solicitor on the other side. Now, quite often, particularly these days, particularly in low value actions, simple procedure, for example, you're up against a party litigant, so you don't have a solicitor on the other side. But where there is a solicitor on the other side, there can be issues in terms of a conflict between looking out for your own client's interests and not wanting to get another solicitor into bother. And it's a difficult one. It's always, where there's a conflict, your own client's interests have got to take priority. So you can't sacrifice your client's interests to give a colleague a heads up that they've forgotten to do something, in my opinion. Somebody once said that litigation is a form of warfare, where you basically go in there to win, and to do that you have to prioritise your client's interests. So if a colleague has messed up, hasn't asked a vital question, hasn't lodged a document that they should have lodged, has forgotten to plead something, you don't, in my opinion, you do not draw the colleague's attention to that. Which isn't to say that I'm favouring a kind of bag of ferrets approach where the solicitors are all fighting amongst each other, but as I say, the client's interests have always got to prevail. There is, of course, the difficulty that clients come and go, whereas your colleagues will be around for probably for quite a while. And people, lawyers particularly, do remember someone having done a bad turn. I mean, I remember doing a debate before Sheriff Principal Norman MacLeod, and a lawyer on the other side pulling a case out of the hat, as it were, which completely scuppered my argument. And he hadn't given any notice he was going to do it. And I'm not one to bear grudges, but I've never forgotten that one. Never forgotten that. So don't go in there trying to get one over on your colleague. You'll fight the case, but don't do it in a way that is unfair or unethical. So I hope that I've covered the different risks that there are in conducting a proof. I hope that I haven't scared you off wanting to do a proof if you've never done one before. I'm just going through my notes to see if there's anything else that I should mention. Preparation, I think, is the key thing. Most problems that occur on the day could be minimised by a good preparation. Well, here's something in my notes that I should mention. I always talk about this one. This is, be careful when I was talking there about your colleagues, be careful about being seen by the client to be fraternising with someone that they would regard as an enemy. I've seen that happen a few times, where you're sitting there with your client after a bruising proof, where your client's maybe been subjected to vigorous cross-examination by the lawyer for the other side, and then you've been joking and chatting with the lawyer afterwards, and the client sees you doing that. I mean, that looks bad, because they won't appreciate, clients don't appreciate that when we're acting, it's not personal, we're just doing our job. I mean, they don't see it like that. They'll see it as being that you're being friendly with somebody who's been hostile, threatening, intimidating, and so on. Sometimes I think as lawyers we lose sight of the fact that courts can be very intimidating places for clients and witnesses. Very often witnesses are left sitting in a witness room for hours without anyone telling them what's happening. They're nervous, they're anxious, they don't want to be there, they're on edge, they're bad-tempered, and as I say, if you're fraternising with somebody who's just been giving them a hard time in a witness box, they won't react well to that. So if you are going to have a chat and a laugh with the opponent, the lawyer on the other side, wait until you're in the bar common room or outside or wherever, but don't do it when the client's there. That's never a good look. Yes, so the rest of the notes that I have here are essentially concerning preparation, so I'm not going to go into all that, because this talk has now been going on for an hour and 3/4, which is a lot longer than the Law Society requires a risk management talk to last. So I hope that what I've said will be of use to you in trying to minimise some of the risks involved in proceeding with a proof, and thank you for watching.